Sorry, our machine was turned off.
Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable James A. Edwards, Chief Judge presiding. All persons having business before the court draw near, give attention and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning, everybody. We're here for a oral argument session. We have one case on our in-person docket this morning. As our marshal told you, I'm Judge Jim Edwards. To my right is Judge Scott Makar. To my left is Judge Joe Boatwright. And the case we have on the docket this morning is Curtis Lee versus the Office of the State Attorney for the 4th Judicial Circuit, case 23-317. If you have a noise-making device, please put it on silent or vibrate because it's bound to go off at just the wrong time. With our system here, if you're not familiar with it, we typically reserve 5 minutes rebuttal time for the appellant. If you want anything different, just let us know and we can take care of that. The time shown on your clock will be your entire time. It's not that plus your rebuttal time. When the yellow light's on, that means you're into your rebuttal. When it's red, it's time to sit down. And if you seem to miss either cue, I'll try to help you with that. So, with no further ado, counsel for the appellant.
May it please the court, counsel. This case involves Mr. Curtis Lee. My name is Brooks Rathett. I represent Mr. Lee. Mr. Lee exercised the fundamental constitutional right to access public records. Basically, he made public records requests to the state attorney's office. There were 2 days of evidentiary hearing based on Mr. Lee's contentions that the state attorney's office had violated Florida's Public Records Act, that it had not acted consistent with the liberal construction of the act, with the expansive nature of protecting citizens who make requests under the act, and with the strict laws of the act itself, Chapter 119. And we cited to RHEA case, R-H-E-A case, that kind of explains basically those fundamental principles. Well, what was Mr. Lee's contention and what did the trial court get wrong in our opinion? First of all, Mr. Lee, when he made these requests, there were lengthy delays in acknowledgement of the requests themselves. The statute itself, at Chapter 119.071C, says that a custodian, an agency like the state attorney's office, must acknowledge requests promptly and then respond in good faith. So there are 2 parts to that. There's the acknowledgement and there's a response. And the statute's quite clear, and it's consistent with the case law that reads that statute as protective of Florida citizens' constitutional rights to access. And so the acknowledgement was not prompt. The trial court's judgment, final judgment.
And which letter are you talking about, or email?
June 3rd, the June 3rd of 2019 letter was 80 days until acknowledgement.
Is that the investigation or the request of the investigation with Judge Flower?
Correct.
And were there any documents?
There were no documents.
So I think the state argues that since there were no documents, then that bars any claim under the Public Records Act. Is that correct?
That's their argument, and it's an incorrect argument.
Okay, and why is that?
Because they're relying on Grabsky and Skeen and the case law that says when you serve a complaint or a writ of mandamus type complaint, where you're trying to compel the government to produce a record, those cases stand for the proposition, if that record doesn't exist, then there's no basis for mandamus. You can't compel an agency to produce something that doesn't exist. And if you know it doesn't exist, what are you filing a lawsuit for? If you don't know it doesn't exist, and you file a lawsuit and it turns out it doesn't exist, it pretty much moots the mandamus, though. What are you going to compel them to produce? That's the production of the records. We're talking about the acknowledgement of your request. That's where the delay was here. That's a violation of the Public Records Act.
Was the June 3rd request, is that the one that was supposed to get flagged by their email system and did not?
Correct.
And then Mr. Lee sent a reminder or follow-up in August?
Correct. August 22.
Well, that's when the answer was, I think.
I'm sorry, yes. He sent a
I
follow-up
think he
in-
sent it like August 8th.
Correct.
They entered it into their system, their portal, August 12th, and by August 22, there was a response, is that correct?
The response being there is no responsive documents, correct.
So under the Public Records Act, is the agency required to be perfect and never have anything like that occur where something falls into the cracks?
Well, under the case law of the first DCA, the Lee case versus the Pension Board, the good faith efforts or even negligence or mistakes are not excusable for a failure to
Well, this,
comply.
did anybody prove that this was negligence?
Well, it certainly wasn't prompt response, which is
Well, but
the statute.
is this a strict liability act? In other words, if, act to God, I mean, we've all experienced computer problems. If you haven't, you will.
Right, correct.
But I mean, if due to a computer problem, which seemed to be they had this rule set up for their Outlook system so that any correspondence from Mr. Lee got flagged, a copy was sent to the Public Records Division and also to Miriam Nelson, and for whatever reason, to this day, nobody has shared with me, not that they need to, but it's not like they were negligent in setting it up, they ignored it, whatever else. Something happened bad so that that particular email didn't get to the attention of the people doing the records responses. Is that your understanding?
That's what some of the evidence showed. I don't know if that's correct, that there's not another way to promptly respond. If they put it in the flag system, but there's also other people in the custodian's office, there are other people that get these documents. The people that first got the document could have noted it to somebody else. Here's a public records request, let's respond promptly, because that's what our duty is under the statute, is to respond promptly, because in some cases, if the information is vital and needs to be found out within days, or if...
Let's talk about this case.
Okay, yes, sir.
So, I mean, again, the competent substantial evidence in the record supports the judge's finding that this failure to promptly respond to the June request, you know, if you look at the June date, they didn't respond until August. If that was some kind of a delay, that was due really to the Outlook, wasn't it? That there was a failure of their safety net, if you will.
That's what the judge found the evidence to show in her opinion, but I don't think that is excusable under the statute, because otherwise you create a situation where every agency creates its own process for promptly responding, and when they go wrong, people don't get their responses promptly. And that's not the construction as such, it's not the purpose of the statute, that the mechanisms are to be in place to promptly respond. Now, there might be issues about promptness. Is it fair to say a week delay because of that mistake or failure to flag? Is that prompt? Is that a discretionary basis for a judge to find promptness? Perhaps. There's case law that goes all over the place on days out. But when you're talking 80 days, it's no longer excusable. There has to be some kind of determination at some point that you can't just not be prompt when the statute says you shall be prompt, and then say, well, we messed up 80 days ago, and that's why we're 80 days late. That's, I think,
So is the determination of being prompt, is that a factual determination that the judge is able to make? Because I think there's an argument over what the standard of review is also here, correct?
Correct. And
so is that a factual determination, or is it a de novo standard? I think the state argues that this is under competent substantial evidence, correct?
Yes, I think it's a combination of both, in that the interpretation of the statute and prompt and the case law on promptness would be de novo standard. Weighing the evidence of whether Mr. Lee had something to do with the delay, or, was there, like Judge Edwards said, was there a safeguard that didn't come into place, and is that why things were not prompt? Those might be factual determinations. But I think promptness, there have been legal determinations, and the interpretation of whether she applied the statutory language that says shall be prompt or not is a de novo review. This judge's application of the language of the statute and her interpretation of it, and whether she read it liberally or illiberally, I think are de novo review issues. So I think this case has a hybrid, a combination of both. Mostly de novo, because much of the factual issues, many of the factual issues that the state attorney relies on are things like Mr. Lee's motivations, his personality, why he did what he did. None of that, in our opinion, is relevant at all to a determination of whether there were violations of the Public Records Act. And with the June 4th letter, we also have raised the June 4th letter, and the judge said that one was not properly to be analyzed because it had not been pled specifically in the complaint. And again, that's an illiberal reading of the statute and an unfair due process to Mr. Lee, and here's why. Because Mr. Lee was told by the state attorney's office that they never received the June 4th letter, that they didn't have it, and not until the evidentiary hearing. Only at the evidentiary hearing was he told, we had that letter. So the question to the trial court was it a violation of the Public Records Act, which says you must promptly respond, to not do so with the June 4th letter, one that Mr. Lee didn't even know there was a problem with because he was told it was never received. That's why he didn't plead June 4th specifically, because he was told, we didn't get it. So he followed up on it later, and then they did respond, said no responsive documents. But again, the question of whether the strict language of the statute that puts the burden on the agencies, and that was another de novo, I think de novo issue, and an issue for this court, and a problem with the trial court, was that the burden over and over again at evidentiary hearing, yes, the burden ultimately is on Mr. Lee to prove a violation, but the burdens of how to perform under the statute were put on Mr. Lee as well, which was unfair. The burden of how to comply with the statute and not violate it is on the agencies. It's on the government. It's in the statute. It's in the Constitution. And there's a portion of the statute that allows for citizens to enforce the act. It's an interesting statute in that sense. It's a citizenry or media or whoever it might be goal to enforce the act, because how else do you prevent these violations? How do you do it if people don't enforce the act? And so the first problem was that delayed acknowledgement, which is very, not strict liability necessarily, Your Honor, but very strict. I mean, it says must because it says must. The legislature said it for a reason. And it says promptly acknowledge. And those things did not happen with June 3rd or June 4th. And June 4th should have been allowed by this court because, again, we deal with cases all the time with negligence and other issues of trials, and Your Honors have probably seen where people say trial by ambush is not allowed anymore. Now, I'm not suggesting that it was trial by ambush, but it was surprise to find out only at the evidentiary hearing that, oh, indeed, we did have that letter all along and we didn't acknowledge it. So what is the legal basis or legal justification to not find that to be a violation?
Well, counsel, if I could ask a quick question.
Yes, sir.
The statute speaks in terms of promptly acknowledging. It doesn't use the adverb promptly as to production. There's other standard for that. So if you have a situation where a request is made, acknowledgement isn't prompt, but production or response is within a reasonable time, are you saying that's a violation of the statute?
Yes, because requesters need to know whether something exists or not, or what the status is of the request, because maybe they need a deed to get it.
But when they acknowledge, all that doesn't provide you any information other than the agency has received the request, and they're acknowledging they received the request. It doesn't do anything to say about whether a responsive document exists.
Well, it creates also then the situation where, should I follow up? Should I sue? You know, we now have a portion of the statute that allows for agencies to go after people that sue and say, you brought this in improper motive. Well, if you acknowledge promptly, and I know you're working on my request, that creates a different motivation for how to respond or how to act moving forward than if it just lays there dormant. And so there is an important reason for acknowledgement to know that your request is being worked on.
I see what you're saying, but at the same, is there a legal authority? Is there a case? I mean, I know what the statute says. It says must promptly acknowledge. But has a court, any court out there, or is there any rule somewhere that's kind of more closely defines or finds a violation I should be more clear, finds a violation of the statute based upon failure to promptly acknowledge.
I've not seen a case that directly addresses that this is a violation because of improper delay in acknowledgement. There are cases that incorporate that language into the overall response and says responses must be responded to promptly and acted on in good faith.
But you can't, as we sit here today, no agency or public official has been found to have violated the act because they failed to promptly acknowledge.
I have not seen a case that says prompt acknowledgement alone is a violation.
Okay.
But I have not seen a suit brought for that reason. And, you know, that raises issues of standing too, is if you know an agency is not responding promptly and on a regular basis, what is the redress of that grievance for the citizenry? If it's, you don't have standing if you didn't particularly make a request, but you know this agency just, maybe it's a small town, maybe it's overburdened, maybe it just can't, it's ignoring them and not getting to them. But what is the redress for the citizenry? Well, it's in the statute that you can enforce the statute. And if an agency is violating, and that is, you know, I think just because a court has not ruled on that doesn't change the fact that it is a violation. I mean, if you read the language and you interpret it to be liberally construed in favor of the citizenry, then that is a violation. It might be a minor one. It might be one without great damage, depending on the circumstances. But a violation is a violation, and the citizenry has the right to enforce the act. And beyond the acknowledgement issue, though, there was delay in production. And the statute says there has to be prompt acknowledgement and good faith response. And here, Mr. Lee did not get, he still hasn't gotten an August 28th, 2018 policies and procedures document. He's gotten other policies and procedures documents. He hasn't gotten that one. Now, again, it is not for the trial judge to decide, should he have it? Does he need it? What does he want to do with it? That is not the Public Records Act. The Public Records Act, and I see I'll reserve rebuttal, I'll go one more minute here. The Public Records Act is designed for the agencies to get the records to the requester. There's no legal basis for why that document wasn't produced. There's no legal basis for why the burden memo that we refer to as the burden memo was a memo that was the genesis for this whole policy of we do a burden charge, why that wasn't produced. And again, the trial court should have found that was a violation. The trial court might have said, well, we excuse it because of lack of standing, and I'll get to that in rebuttal. Maybe there's an excuse, maybe there's a reason, but there's no question that the evidence, regardless of what the state attorney's office or the trial court thinks of Mr. Lee or his motives, there's no question that that should have been produced. The argument being vagueness, that was rebutted by their own letter that they wrote pre-suit. An attorney for the state attorney's office wrote a letter where he gave his opinion, and he created a public record and gave his opinion of this is why we do what we do with the charge, with the burden charge. This is the legal rationale and justification. We know you want that answer. I'm giving you that answer in my words, but didn't give a document that they knew existed.
You keep talking about the state, the court's view or the state attorney's view of Mr. Lee and animus and all the rest of that. Is there any evidence in the record to suggest that the state attorney failed to acknowledge or failed to produce documents based on their feelings, for want of a better word, about Mr. Lee?
I can't answer that. I don't say that to be flip, in that I can't understand their motives necessarily.
So I said, is
Yeah.
there evidence in the record that they refused to acknowledge or failed to acknowledge or delayed any response because of their animus or feelings towards Mr. Lee or their response to his feelings towards them?
There was no evidence where they said, because we don't like Mr. Lee's approach or the way he's acting, we are not going to give him a document. No, there is not. There is contention that might have influenced the way they responded to him and that type of thing, but I can't point to this is why this was 20 days later or so forth. No,
You
Your Honor.
want to save your 2.5
Yes, Your Honor.
minutes? All
Thank
right.
you so much.
May it please the court. Michael Lockamy on behalf of the Office of State Attorney. To get to your last question, the answer is no. There is no evidence in the record that the state attorney didn't produce documents because of the animus. In fact, the evidence is to the contrary. They knew that he was likely to bring litigation, and so they went the extra mile to make sure that they tried to understand what he wanted and to provide those documents to him. Mr. Rathett also said in his opening that Grapsky doesn't apply, and the fact that they have to prove that there are responsive documents. And he said that it doesn't apply because that was a mandamus action. If you look on page 194 of that opinion, they ask for declaratory relief just like this case here. Grapsky applies. This case, they can't point to a single document that we failed to produce in response to the June 3rd or the June 4th requests that they made. They do point to documents for the verify and justify questions, and I'll walk through why those were not responsive as
So
the
you're
court
saying
found.
if there's no documents in regards to the June 3rd request, then you don't need to ever respond to him?
No, I think you have to respond and tell him that there are no responsive documents,
So
just
what
like they
would be a
did.
time period for that?
I'm sorry?
What would be a time period for that?
It's as the cases lay out, it depends on the circumstances of the case. It is not a strict liability as Mr. Rathett said. In fact, under the Lickler case, under the Jackson case, when you're talking about delay, you've got to look at the particular facts. Here are the facts that the trial court heard here. Mr. Lee sent thousands, or at least hundreds of emails to the SAO. He knew that the SAO had a public records department, that it had a specific email address that he could send requests to, and that he would get a quick response if he did that. Instead, he sent it to the state attorney, Melissa Nelson, and he put the request on the third page of an attachment to an email. We know that there was a technology failure during that brief time period in June where it was not forwarded along. We also know that when it was brought to their attention and when they learned of the request, they immediately, Miriam Nelson asked around to see if there was an investigation. There wasn't. They promptly told him so. So by August 22nd, they had acknowledged the request. They had closed the request. And we also know from Miriam Nelson's testimony that he received not only the acknowledgement, but the response before the typical time that it takes the SAO to respond, the 90 days. They make a big deal in their papers about the 90 days. If you look at Miriam Nelson's testimony, all she said is our goal is to get out the responses in 90 days. There's no automatic delay. There's no delay at all. That's just the typical time frame that they look for to try to get requests and to measure themselves as a department.
So your rule, the SAO's rule is 90 days. They have a 90-day policy?
That is disingenuous. That's a disingenuous argument by them. Her testimony was, we get them out as quickly as we can.
So there's no 90-day policy?
The policy is first in, first out.
Okay.
And I asked the question during the hearing, I said, how long does it typically take? What's the typical lead time? And she said, it typically takes us 90 days. That's what we try for. It's a measuring stick. It's a goal. It's not a limit, and it's certainly not an automatic delay.
If you could clarify that, because it sounds like we try to get everything done by 90 days. That's sort of like we have an aspirational goal at the court to get our opinions out within 180 days, and that's the outer limit versus the average. So is there evidence about how long it takes on average?
All we have is her testimony where I asked her, what's the typical response time? And she said, we shoot for 90 days. That's our goal, is to get out. And we know that they have about 2,000.
Again, that's kind of ambiguous. We typically like to not have it go more than 90 days, or is it typically that we average 90 days? So it sounds like, I don't know, whatever the testimony is, but it's not clear to me what the 90 days stands for. If it's If it's an outer limit, if it's like our goal is to have everything never go more than 90 days, that's much different.
So I asked her, the question was, tell us about the typical response time to a request. The answer was, we try to. Our goal is to get them out within 90 days. And then I asked, and in the 2018, 2019, 2020 years, did the office, was that typically the time frame to produce documents? Yes. That's,
okay,
that's
so-
the extent of her testimony on the 90 days.
Well, it's still not clear to me, but if you could, Mr. Rath had said something to the effect about, we still don't have an August 28th policies and procedures. I don't know if it's a manual or whatnot, but can you talk about that for a moment?
Sure. So that goes to his verify and justify argument. And the verify and justify argument is based on a October 24th, 2019 invoice that he received. It's at the record at 1117. And if you look at that invoice, the state attorney charged the extensive rate. The extensive rate is the rate that they had always charged 2018 and before. It was not a new rate. It did not charge the extended rate, which is the rate that they began in 2018 and started before, that includes the employee benefit portion. So it only focuses, that invoice that started this whole tranche of request was only about the extensive rate. He responds, after getting that invoice, he responds and asks for documents verifying. He references the 10/24/2019 invoice, and he says, please provide documents verifying and justifying such hourly rates.
That's his October 31 correspondence?
Yes, sir, at the record 1093. Miss Miriam Nelson responds, please clarify which additional documents you wish to obtain. That's the same day. The following day, he says, start all over, think about what I asked for. I have gotten different invoices that sometimes charge me different hourly rates. My logical reaction was why? I want what I asked for, SAO documents, details, and formats unknown that show or explain why, that verify and in the SAO's opinion justify the differing rates for labor that were used at different times vis-a-vis. She responds back and says, go look at the policies and procedures manual that is in the public records portal and that's on our website. It provides the rate information. That's at 1097. That policy manual that she referred him to and that you'll see he went and looked at was the one that was in effect at the time of the invoice that he was questioning, and that would have been responsive to his question if he wanted to know what was that extensive charge. She referred him to it. He went and looked at it, and he wrote her back. And at 1103 of the record, he says, you emailed me no responsive documents. You told me instead to go online and look up the document you call the SAO's Public Records Division Policies and Procedure. This was rude and defiant of my rights. I spent extra time doing so, and that document was not responsive to my 1031 PRR letter. So the policies and procedure manual that was effective at the time that the invoice was sent, he says, not responsive. He then goes and reiterates again, send me documents that verify and justify with documents the hourly rates the SAO assessed. There's no talk about a legal justification. There's no request for the genesis of the extensive rate or the extended rate. The invoice didn't even have the extended rate on it. All of these things have been made up in this litigation.
Well, so it sounds to me like what they're saying is we want a hard copy of this. You directed us to the website or to a file or whatever, no?
No, sir. He wants an earlier version. He wants the 2018 version. She sent him to the effective version of it. He has that. He read it. He's now saying that we should have provided a policy and procedure manual that was out a year and a half before that didn't have the effective rates in it, that was old, that had been replaced.
Well, if you wanted that, you would give it to him, wouldn't you?
Absolutely, but he didn't ask for that. He was questioning a particular invoice, and she pointed him to the handbook that was in effect at the time. And he says it's not responsive. But somehow an earlier version that's out of date is now responsive. We don't understand that.
Is there any evidence in the record about the number of annual public records requests that are made to the Fourth Circuit State Attorney's Office?
Yes, Miriam Nelson testified that there are roughly 2,000 made annually.
And how many did Mr. Lee make on average?
I don't know if it was annually or what the parameter was, but they said several hundred. I think the number was 400 maybe.
So,
He is by far the largest requester of the SAO.
it'd be 20%.
Yeah, I'm not sure if those time periods are the same, though. It's 2,000 annually. I don't think he did 400 in a year. I think that's 400 over the time that Ms. Nelson has been in office.
Oh, okay.
So the time periods may
So
be
much,
different.
a smaller percentage, yeah.
Yeah. These correspondence go on and on this issue of verify and justify. She ends up explaining to him, she says, look, you don't need to ask for documents to understand the charges. I'm happy to explain them to you. And in the record at 1033, she goes through for 4 pages and explains the difference between extensive and extended. She explains how the hourly rates are computed, and she provides him the underlying information. Previous to this, she had provided him the hourly rates of the employees, their salary information, so he could do the calculation himself. Then she provides a 4-page email to explain all this to him. And at the end, she says, and I'm reading from 1036, please note it's taken me approximately 4 hours to draft this email, obtain the documents that are responsive, request documents again that have all the fields you requested, and make sure that I reviewed each place responsive material to the above could be located. This is time that you will not be charged for. 4 hours worth of work. His response back to her, and this is at 1033, he says, thank you for your responses and accommodation. Thank you for answering questions. Over the years, I've dealt with some government employees who have been extremely irksome. I have faced absolute refusals to answer my questions at times. Hence, to be safe, I tend to ask for docs showing this or answering that to obviate such conduct. You have provided me much information. I may get back to you later if I need more, etc.
Her correspondence on that response was in March, is that right?
March 8th, 2020. Yep. And she responds to that and says, I am glad I was able to assist and I remain available for any questions. She then testified to the trial court. I thought he was satisfied based on this, that he had the information that he needed, and he never came back and asked for more on these topics. And that's in the court's order. That's at
Mr. Lee confirmed that in his testimony.
He did, yes, sir. And so, to the office's belief, his records had been satisfied. Since this litigation started, and really at the trial, he says this August 2018 Policies and Procedures Manual is somehow responsive to these requests to justify an October 2019 invoice. That Policy and Procedure Manual does not have the rates that were in effect at the time. The court found that it was not relevant and not responsive to the request, and we think you should find as well. The other issue is he points to an email from July of 2018 that discusses the potential implementation of an extended rate, and that would be a rate of the employee's hourly rate plus their benefits for requests over 2 hours. He wasn't charged that in the October 24th, 2019, but that was explained to him later. The burden, what he calls the burden fee, but the extended rate was explained to him later. Again, that singular email that discussed whether they were going to charge that was not responsive to his request on 1031 or any of the follow-up ones either.
If I could clarify, if he's requesting the 2018 policies and procedures, it may be because, at least I don't know if this is the case, but maybe he says, well, I made some requests during that time period. Obviously, he probably did, since he's been making over the years. So why wouldn't he be entitled to the 2018 for that purpose?
No, he absolutely is. If he asked for it, we would have provided it to him. Our point is the request that he made was give me documents that justify this invoice from 2019. And our point is a manual that's out of date from 2018 says nothing about the rates he was charged in 2019.
And his request was never clarified. In other words, he never said, oh, I don't really want 2019, I really want the 2018.
Correct. Okay. And, well, not until 2022. He then asked in 2022, which is why we produced it to him in 2022. But you're right, had he asked for the out-of-date policies, there's no reason why we wouldn't have given it to him. The singular reason we didn't give it to him is it wasn't responsive to his request, which went back to the October 2019 invoice.
One question, it's not particularly relevant, but I couldn't find it in the record. Is the Fourth Circuit's judicial policy to have cases like this sent to another circuit? Because I saw there was an order of recusal by the original trial judge, but then I didn't see another order in the record that had this case go to the Judge Weston in the Seventh Circuit.
I know there were a number of recusals, and I can't remember if it was in this case or in his earlier one, because he filed this same case in March. I know there were a number of recusals, and then the chief judge then sent it to Judge Weston, but I'm not sure the reasons for that.
Okay, yeah, I couldn't find out either, so.
One question that y'all asked previously was, is this a strict liability statute on the timeliness? And it just can't be. As the case law points out, you've got to look at the facts of the particular case. For instance, if you have a hurricane come in and somebody makes a request right before the hurricane, there's an electricity outage, it's not a violation if it takes a few days to get back. So you've got to look at the facts of the case. And we believe that given the facts here, given how he made this request, that it was not conspicuous, given that he buried the request in an attachment, given the technology failure, and the fact that the acknowledgement was made soon after they brought this to the state attorney's attention, that it cannot be a violation. And I would point to the Consumer Rights v. Union County case. It's a case out of the first DCA. In that case, there was an email sent from a suspicious email account that requested documents. And the recipient thought it might have been a phishing scam and did not respond at all, did not acknowledge the request at all. For 4 months later, they file suit. No acknowledgement had been made. At that point in time, the county realizes, all right, this is a legitimate person or business behind this. We're going to fulfill the request. They do so. And the trial court said, that's justified. It looked like a phishing scam. We understand why he didn't get back to him. There wasn't an undue delay. And the first DCA agreed. It's not delay on its own. It's unjustified delay. And here, with the technology failure and all of the other factors that we have, especially the fact that they not only acknowledged, but they responded quickly and said, we don't have any documents, we believe that any delay was justified.
Is the justification or good faith on the part of the state attorney's office a question of fact, a question of law, or a mixture of the two?
I think it's a question largely dependent on fact, and I believe that the substantial competent evidence below should have great deference from this court.
Where do the attorney's fees motions stand?
We have a motion for attorney's fees that was stayed by the trial court once he filed his notice of appeal.
And both have moved for attorney's fees in this court?
Yes, yes, that's right. I won't touch the acronyms issue other than to say we're talking about the acronyms ASA, Assistant State Attorney, DUI, and DIV for division. I mean, those were the acronyms he wanted. There's no obligation for us to create documents, even though we did, to provide it to him. And then we even offered to create a larger document that would have a comprehensive list of acronyms, and he refused to go forward. But there's no case that says we're required to create documents for him, and we've produced those that were responsive. To conclude, Miriam Nelson is the paralegal that was at the heart of this, and she's the head of the PR Public Records Department, and she's supposed to perform the final review of most of those 2,000 requests that she gets a year. She testified, we look at ourselves as a customer service department, talking about the Public Records Department. We pride ourselves on providing a service to our requesters, and we uphold Melissa's vision of transparency. Instead of looking at requesters as a burden or looking at records as something that we don't want to give over, we look at it as a service that we're providing to the public, and we want to give people whatever they want as long as we can. This testimony is backed up by the voluminous emails that you see in the record. I urge you to look through them. She could not have been more helpful to him and more inquisitive as to what he wanted, and it leaps off the page at you. If he would have been clear as to what he wanted, he received it. The times that he wasn't, she followed up and asked him. You'll see that she made a genuine effort to understand what records Mr. Lee wanted and to provide them to him. You'll see a model of professionalism and a helpfulness that goes far beyond the act. There was no violation of the act. We'd like for you to affirm the judgment.
All right, thank you, counsel.
Thank you, Your Honors. I'd like to address the suggestion that we make the argument that the 90-day is a hard and fast policy. We did not allege that. What we alleged was that it's an illiberal interpretation of the statute to allow a government agency internally to set 90 days in its mind or in its practice as this means we've met the good faith requirement, which is a requirement, that responses must be made in good faith, for agencies to be able to internally say, if we make it by 90 days, we have done that.
Did the trial judge make any findings on that issue?
No.
So how, I mean...
She
was there-
should have found that's a violation.
Did you-
That's our argument.
Did you
is
ask for a rehearing on it to try to get her to clarify it and address it?
I did move for rehearing on that and said that that's a violation. There should have been a finding that that's a violation, that the 90-day internal position is inherently a delay. To think that you can, if I get this out in 89 days, I've met my burden, is not consistent with the statute, the law on the statute, and the liberal interpretation of the statute, because you've now justified delay.
Were any of the requests in this particular case beyond the 90 days? Like what was the longest one in your mind in terms of what you thought?
Well, the burden memo was years. That was produced after lawsuit, and that's something I want to address in rebuttal. The burden memo was produced after lawsuit. The 828 Policy Procedures Manual has never been produced, and case law that Ms. Nelson, Miriam Nelson, who was just quoted, she testified was also a basis of their charging policy. They researched case law, and they had case law, has never been produced either. Now, those things were never produced. That non-production, there's no legal justification for that non-production. The defense is that the requests were vague. The November 7th letter said specifically, hence, I have reason to doubt the propriety and legality of being charged $50 per hour for ASA time. And then he asked for the justifications, the rationalizations. And the evidence that shows that they knew exactly what he was asking for was prior to lawsuit, Mr. Siegel sends a letter to him saying, here's my view on the justification, which is fine. That's polite of him to do that in some respects. He was also sort of scolding Mr. Lee as well. But he did that. But that doesn't justify not producing the documents. And they were not produced.
All right, counsel, if you'll sum up, I'll give you a few seconds since I let the others go a little long.
Oh, that's okay. We have moved for this to be reversed and sent back to the court to find violations of the act. Mr. Lee sought declaratory judgment that there were violations of the act. There were violations of the act. The acknowledgments were not prompt, and the rationales are not justified for the lack of promptness in the acknowledgments. The delays in producing documents that should have been produced are not acceptable and are violations. The non-production of the burden memo, the 828, and the case law is violations. And the
All
main...
right, thank you. Your time's expired, and your extra time has expired.
Okay, thank you so much.
And we will be in recess.
All rise.